if you are employed in a certain company, that company does a certain type of business, you gain a lot of knowledge, a lot of skills, you get clients, you get contacts by virtue of working there. So the day you leave, can your former employer stop you from not opening a business similar to that? If you are a barber, you cannot open a kinyusi. If you are a musician, you cannot sing until 1 year ends. If you are a journalist, you cannot work in any media house for 1 year. So if they put the clause properly, if you are working at Kayole, then you cannot open a business in Kayole. But it cannot stop you from going to Kisumu and opening a business there. Welcome to Court Helicopter Explainer. We are happy you are part of us. We celebrate you as the person who has followed us, and we know very well that my people, the Lord talks of my people, the Bible talks of my people suffer for lack of knowledge. Court Helicopter decided as the editorial policy to get you knowledge. Today we are dealing with non-compete clauses. What is that? Bramwell got this and everybody was asking, what is that? Non-compete clauses in employment? What does it mean? Simply, non-compete clauses is a simple thing. If you are employed in a certain company, that company does a certain type of business, you gain a lot of knowledge, a lot of skills, you get clients, you get contacts by virtue of working there. So the day you leave, can your former employer stop you from not opening a business similar to that? You are employed working for Danstan Omari and Associates as an advocate. Can you open another business when you leave of a law firm next to Danstan Omari and Associates? You're working for Court Helicopter News. You know all the tricks and all the customers and all the people who bring adverts to Court Helicopter News. Can you open your own channel next door? Call it Bramwell International News. That is the question that we have. Many will argue, why? I'm free. I'm free. Court Helicopter employed me with my qualification. I have my degree. I have everything. I have I have a law firm. I have a practicing certificate. I am an engineer. I'm an ICT person. I'm a marketer. Why should I be bound that I cannot open a business? That is now what we call the no-compete clauses. This is the question that went to course number 770 of 2018 in the Employment and Labor Relations Court. This is before Justice Helen S. Wasilwa, and the judgment was on 27 September 2018. Craft Silicon Ltd. were the claimant applicant, and Niladri Shekhar Roy. What are the brief facts of this matter? In paragraph 3:1, he says, the respondent This is the person that has been sued by the company, worked as an employee of the company, where he executed an employment contract that contained a surviving non-compete clause that expressly prohibited the respondent for a period of 1 year from engaging any of the claimant's clients after the termination of the employment contract, disclosing the claimant's confidential information obtained while in the claimant's employment, and rendering any service that is in competition with the claimant's business. So this person, when he was employed, he was given a contract. In the contract of employment, there was a clause that said, 1, he cannot for 1 year after leaving engage the clients who were his employer's clients. You are a barber. You have been employed to shave people. Then you are given a contract that when you leave, among the people you are shaving is Bramwell, is Omari, is Vivian, is Cyrus. You cannot contact them for 1 year. 2, you cannot disclose your employer's confidential information. Every business has confidential information. You cannot disclose. Lastly, you cannot open a business similar to your employer and become a competitor for 1 year. If you are a barber, you cannot open a kinyusi. If you are a musician, you cannot sing until 1 year ends. If you are a journalist, you cannot work in any media house for 1 year. If you are a lady of the salon, you cannot open a salon for 1 year because that will be seen as competition. What happened? The employee went and was employed in another company that was doing the core business similar to what the former employer was doing. Paragraph 4, he also directly engaged with the claimant's clients and is using confidential information for purposes of jeopardizing the claimant's relationship and standing with its existing clients. This was the case that went to court. What did the judge say? The judge said, and this is in paragraph 29, an employer cannot restrain an employee to earn a living. The clause is indeed vague and not kept within any geographical boundaries. So the judge did not agree because that clause did not say the geographical boundaries. So if they put the clause properly, if you are working at Kayole, then you cannot open a business in Kayole. But it cannot stop you from going to Kisumu and opening a business there. So you can be barred to operate within certain geographical clauses. Paragraph 31, I will, however, only allow the application in part by ordering that the respondent should not contact the claimant's customers in any way during the period of 1 year since he resigned from the employment as per clause 9D of the contract. This will be so pending the hearing and determination of this claim or until the period of restraint elapses, whichever is shorter. So the law, the judge agreed that employers can ask an employee to sign non-compete clause. So today, you know, if you have been given a job and there is a non-compete clause and you have signed it, and one, it spells out that within 1 year, you cannot open a business around, it is around a certain geographical area. 2, you cannot contact the former clients. Many people are scared of employees. The employee, you have a shop here. Your employee opens another shop similar to yours and poaches all the customers that were there. Now you know, as an employer, you have got to have a non-compete clause for all your employees. 2, for employees, you now know if you have an intention to open up your business as an entrepreneur, then it must be a way. This is a very controversial decision courtesy of Bramwell. Now you know that there is no non-compete clauses in employment terms. Wakili Danstan Omari, always a pleasure.